doesn't help you. But one of the things that I noticed last night when I finally hit the sets from those of you who sent me your 3 essays from your Barbary practice exam is, guess what? They use the same question that's in your packet today, which almost never happens. I like to choose older questions for my classes because it's less likely that Barbary or Kaplan or Themis will be using them, but they pick the same question. And so many of you will have done that question, which means I don't want to repeat the whole process. However, there are certain things about that question, some things that are in the fact pattern that you might not have picked up on that I found doing some research that I want to point out. And I also want to talk a little bit about presentation, because that particular area is a good one where I can show you how to kind of bring the law and the facts together instead of just giving a whole list of rules and then a whole list of facts. So that's what we'll do at the end. With that, and before I jump in, any questions, anything anybody wants to ask about besides help, you know? OK. All right, then let's go ahead with the Florida evidence questions. Now, we are going to do all of the questions. It won't take us that long. I haven't covered every single Florida distinction in this question set. And there are a few that aren't in here that I'll mention as we go along. But it's a pretty good summary survey, if you will. And if you can keep in mind Florida distinctions with evidence, you can get a really nice score on this multiple choice component. Now, can I guarantee you that you're going to have Florida evidence on the exam? No. But is it tested a lot? Yes. So I would certainly be prepared for Florida evidence questions. With that in mind, let's just go ahead. The questions are really short, so they're not going to take you real long to do any question. But again, we have to do one at a time for the purposes of the software. So jump into question number 1 and go ahead and ring in. OK, anybody else on this question? It's a short question. You know it or you don't. All right, let's see how we did. Really good. All right, you know under the federal rules of evidence that you can use a learned treatise to impeach, of course, which is one use of the evidence. But you can also, under a hearsay exception under the federal rules, you can use it as substance, of course, if the judge determines that it's reliable and if it's read into evidence while the witness is still on the stand. But Florida does not have that hearsay exception. So a learned treatise in Florida may be used to impeach, but not as substance. And I can promise you, if you get that evidence multiple choice set, that they're going to be testing that type of distinction. You know what the federal rule is. The Florida rule is different. It's that intersection that they're likely to test. Any questions on this one? All right, number 2. Anybody else on this question? I think we're missing a few. Always check to make sure, of course, that your clicker's on. Let's see what we have. Fairly divided. Let's talk about this question. The answer is C. Let me get that off. And let's talk about why C is the right answer. Well, of course, C is the right answer because it comes right out of the rule. But here's you know that Florida, I mean, that's always a good way to go, right? It comes right out of the rule. Florida is very suspicious of opinion testimony in general. And if you're just kind of learning half of the rule, then you think, oh, opinion, and a lot of you did pick B, inadmissible in all circumstances. But you ought to know by now that those absolute answers are oftentimes the wrong ones, right? And the fact of the matter is, in Florida, that lay opinion is not admissible unless. And the question, of course, is, can your witness readily testify without giving an opinion? In real life, that's what you do. If you want to get an opinion in, then you find a way to show that your witness can't testify any other way. So remember, again, right out of the rule, and be very cautious about absolute answers. And remembering, again, though, that Florida is very suspicious in general of opinion testimony. Any questions about this one, since we had such a mix of answers? Okay, number 3. Okay, we're coming up on 2 minutes. Anybody else on this one? Missing a few people? Okay, let's see what we have. Good this time. Let's talk about what's going on here, though, because I promise you, if you have Florida evidence as multiple choice, you will have a question that or maybe more than one question dealing with this particular issue. Remember, under the federal rules, you have 2 privileges that apply to, or that can apply to, married persons. You have marital communications and you have spousal immunity. But in Florida, we do not have spousal immunity. All we've got is marital communications. So if you look at our parties, of course, we've got a husband and a wife. And in this particular case, looking at the different choices, we need to know who can prevent whom from testifying. With marital communications, of course, you need a communication made during the marriage in confidence. And who owns the marital communications privilege? Both spouses own the privilege, both the witness spouse and the defendant spouse. And so either spouse could assert marital communications, but look at D. Clyde may be compelled to testify as to matters not told in confidence. Oh, wow, marital communications privilege does not apply if the statement is not made in confidence, right? So always remember that the statement has to be made in confidence, first of all. Second, both spouses own the privilege. But more importantly, no spousal immunity in Florida. Okay, any questions? All right, number 4. Okay, we're coming up on 3 minutes. We're missing a few folks. Anybody else want to vote? Pretty good, but there are a couple things I want to point out in this question. First of all, it's the kind of question that you have to pay a little more attention to. The first couple of questions we had, you know the rule, you don't know the rule, you get it right, you get it wrong. We've got additional layers in this question, and be on the lookout for that in an evidence question, because you have to understand privileges, but you also have to understand the difference between an admission and a declaration against interest. All right, who made the statement here? Samantha, right? And who is Samantha?
The party.
She's the defendant. So if she's the defendant, she's the plaintiff. I'm sorry. I don't even know my own question. She's the plaintiff. But she's a party. And if she's a party, it's not a declaration against interest. It's an admission, right? So you've got to pay attention, because some people did pick A, declaration against interest. It's not. She's a party. So we can get rid of A. And B says it's an admission, but it's not admissible because it's privileged. And a few people picked B. Florida has no express patient-physician privilege. Now, patient records are protected under privacy. There's a statute that protects them under the concept of privacy. But all you need is a subpoena and proper notice, and those records can be the protection of those records can be pierced. So we've got an admission because Samantha made it, and she's a party, and it's not subject to patient-physician privilege, plus all you need is the subpoena, and the testimony is admissible. So again, you've got a lot of different layers going on in this question. You've got to distinguish the type of statement. And I want to encourage you, whether it's Florida evidence or regular evidence, stop and ask yourself, what is the evidence, whatever it is, statement or otherwise, and especially what's it being offered for. Don't jump too quickly. Really think it through, because you're going to say, oh, it's hearsay. Don't go there so fast. Really think through.
Sorry, you said that it is privileged? But
No, it's not. There is no patient-physician privilege in Florida. We have psychotherapist, patient. We've got penitent clergy. We've got accountant, client. We got everything but patient-physician in Florida.
Does Samantha not need to give consent for the
If
medical records?
if she, well, if she's subpoenaed, yeah, that's the key. If you have a subpoena, you don't exactly have to consent, right? And the subpoena is right in the statute again. Other questions, though? Yes, sir.
Does it matter who it's said to? Like, if it was said to the defendant, would it be a different rule?
Said to the defendant.
No?
No, I mean, it's still going to be an admission, right?
Okay. Is the subpoena required, or can the doctor just testify?
Then she'd have to consent, because, right? Because then that's her record, right? Okay, other questions on this one? All right, number 5. Oops. Anybody else on this question? Coming up on 2 minutes. All right. Ooh, some of us didn't pick up a really important Florida distinction here, because we have a question that involves impeachment through a bad act, which of course you can do under the federal rules of evidence. Florida does not permit impeachment by a bad act, period. That's an absolute, but it's a correct absolute. Doesn't mean you can't use bad acts in Florida, but you can't use them to impeach. If you want to bring a bad act in Florida, what do you have to use? Mimic rule, exactly right. You use the mimic rule. Now, in Florida with mimic, the act has to be strikingly similar. It's maybe a little higher standard than under the federal rules. But nevertheless, you would use mimic, of course, in a criminal proceeding.
I thought you could use bad act testimony when it goes to truthfulness or deceit.
Not in Florida. Not in Florida. You can't impeach with a bad act in Florida. Now, what you can do, of course, in Florida is impeach with a prior conviction, right? You can still use a conviction to impeach in Florida. And the rules are similar but a little bit different. In Florida, we do not have that 10-year staleness rule that you have in the federal rules. And we also don't do the balancing of the probative versus the prejudicial aspects when you have a felony that doesn't go to truthfulness. But otherwise, the rule's pretty similar. So remember, again, no impeachment with bad acts in Florida. Any questions?
So what was the answer?
The answer is B. Answer here is B. And I have, when we take a break, I've got analytical answers for these questions for you. Now, before we do the next question, something that I don't have in the packet, and someday I've got to remember to put it in the packet, is scientific evidence. And we all know that Florida now follows the fill-in-the-blank rule. We follow Daubert now, and they will test that, because up until very recently, of course, we followed Frye. So for Daubert, the evidence has to be relevant and reliable. So remember that, because if you get evidence for sure, you're going to get one question dealing with Daubert. OK, number 6. I'm sorry, wait, question? Yeah. Well, would they test Frye because it's not the rule? Honestly, unlikely. At this point in Florida, they're probably not going to ask about Frye. They're going to go to Daubert because we made that change. Now, does not to say on the MBE that maybe they might test Frye, but certainly not in Florida anymore. Number 6. Anybody else want to ring in on this question? Going once, going twice? Anybody else? All right. All right, very good. As I mentioned before, Florida is very suspicious of opinion testimony. So when we're talking about impeachment, in Florida we impeach with reputation, but we do not impeach with opinion. Pretty easy, pretty straightforward. Any questions on that one? Remembering, of course, that you can use both under the federal rules. Yes, sir?
Were you suing Emerald? Wouldn't Emerald's testimony be a little biased?
Oh, it could be. Absolutely. That's a whole different issue, but sure. But I want to point out, what you don't want to do is jump. It's an excellent question, but you don't want to jump past what's presented to you. So you answer the question that's in front of you, and don't start thinking, well, what about bias, when the call to the question doesn't take you there, right? Okay, any other questions on this one? If not, number 7. Anybody else on this question? I think some of your clickers are probably dying because we're getting fewer and fewer people registering. Look for your little on light. All right, let's see what we've got on this one. Okay, very good. You know, if they test Florida evidence, that you're going to get a question dealing with this point too. Under the federal rules of evidence, an admission is admissible non-hearsay. But under the federal rule, Florida rules, we follow the old common law rule, which viewed an admission as
Battery.
Oh, they didn't put the cord on. Thank you. It's admissible hearsay, right? Any questions about that? That's real simple. All right. One last question I'm going to plug in, but go ahead with number 8. Anybody else want to ring in on this one? So we are missing a few. Okay, let's see how we did. Pretty good. Once again, a place where the Florida rules differ from the federal rules, and where we distinguish in Florida between personal habit and business habit. So, under the Florida rules, personal habit is used to corroborate only. That corroboration requirement's an old common law requirement. It's not in the federal rules. And again, it is a rule for personal habit only. There's no corroboration requirement for business habit in Florida. Okay, it's a real short set of questions because we have other stuff that we're going to cover today. Again, on the break, I put the answers down in front. If you can focus in on the differences, of which there are not that many in Florida, you can clean up on Florida evidence. And you want to do that because you don't know for sure what else is going to be lurking in the multiple choice questions or even in the essays. So when you have a topic that's manageable, that's clear, and that's very likely to be tested, make sure you're ready. Any last questions? Okay, now let's move to a topic that's anything but sure in terms of what's going to be covered, which is Florida Con Law. You've had your lecture in your regular class. Most of you have written essays. Judge Shepard spent a lot of time talking to you about Florida Con Law a few weeks ago, but I want to go at it one more time because it's a difficult topic and there's so much that can be tested. I want to make sure you're really well prepared because I think it will be tested. So I'm going to ask you, most of you have flipped over, find your Florida Con Law question, go to the back, of course, take a few minutes to read this question because this is one that you haven't done in any of your courses, I don't think, and then we'll talk about it. Okay, let's see what we have. Now, first thing I want to note when it comes to this question, it is jam-packed with issues. And honestly, it would be really difficult to write about everything that's in this question in 1 hour's time. I'm just going to tell you that up front. I want us to spot all those issues, and then we'll talk about, well, what do you do when you have too many issues to talk about, and what do you want to focus on, what do you want to back off perhaps a little bit on. So let's take a look at the fact pattern, see how much we can pick out of it. We start with the Sluggers. Professional baseball team plays its home games in Beach County, Florida. So at least we know we're set in Florida. If it's a Florida con law question, okay, it's going to be set in Florida. If you have any doubt, sometimes every once in a while they're going to give you a question, like maybe it's a homestead question or a wills and trust question or something, and they don't tell you where it is. Tell them you're assuming it's in Florida so that you can apply Florida law. Team is owned by a private corporation. Well, there are a ton of cases in Florida. You'd be surprised at how many, dealing with construction of sporting facilities. And obviously, we've had our share of issues. The Marlins, and now we got David Beckham, who wants to, the list is long. And it's usually a private entity that wants to do it. So right there, you're going to have an issue because they're going to want to have, either they're going to want to have eminent domain or they're going to want a tax break or something, and it's a private entity. But they tell you, of course, that it provides an annual economic benefit of about $75 million to the local economy, trying to show you that there's a what? Public purpose, exactly right. So as you read these facts, start to pick them out. Baseball Inc. has said, of course, that it will move the Sluggers out of Beach County unless the county builds a new stadium for the team. And this question, predated the Marlins, but it's exactly what happened here. And the Sluggers can move in within 3 years. So that type of threat is made all the time. Beach County, a non-charter county. And I'm going to tell you, I don't see a lot of purpose of putting that in here other than to say, okay, I know what a non-charter county is, because it doesn't affect the outcome of the case. So here's a place where I would note it, and I do in my answer very briefly, but I wouldn't spend a lot of time talking about the difference between charter and non-charter, because it doesn't affect the outcome of the case. However, if you are not familiar with the difference between charter and non-charter, it's a good idea to refresh on that particular issue because they do like to test it. They want to build a new stadium at a cost of $100 million and on county-owned land in an unincorporated area of the county. Here's an important point now. The county would lease the stadium to Baseball Inc. under an agreement providing the Sluggers will utilize the stadium for 25 years. So we got this public-private partnership that's going on, which again has to do with the use of the bonds. It might also, of course, affect an eminent domain proceeding. In this case, of course, it's not going to be eminent domain because the county already owns the land. But just be on the lookout for that because they do, of course, love to test eminent domain and taking. And that's not an issue here, but it is a frequent flyer. Baseball Inc. would pay the county annual rent of $1 million, which is going to become important in a minute. Each year, the county would also receive 10% of all revenue from the stadium. Why are they putting the rent and the 10%? Because they're trying to set up what kind of bond? a revenue bond, right? Because they're going to use the money from the stadium to pay for the bond. So we know we're going to have bonds in this question. You can see right away. And then, of course, the next paragraph. The county plans to issue bonds to finance construction of the new stadium. The bonds would be secured by a mortgage on the stadium and underlying land. And right there, they've tested this issue more than once. It's not in anybody's outline. It's not a rule I knew, but I looked at the fact the first time I did this question, and I said, that's got to mean something. And so I did some research. And lo and behold, I found a rule, which is that even if it's a revenue bond, if the bond is being used to build a project on land that's subject to a mortgage that can be foreclosed, a referendum is required. Ooh. Yeah, and they've tested it more than once. So you make a little note. It's it's in the packet. I'll put it up in a minute so you can see so it'll be easier for you to read, and we'll go through the rule. But make a big asterisk there because they've tested it more than once, and it's another example of why it's so important to read those facts and say, what's it doing there? Now, mind you, I wouldn't have known what that fact was doing there until I did the research. But I'm going to give you the rule because it's come up more than once. So the bonds are payable from two sources of revenue. Well, they're setting up general obligation bonds and revenue bonds. And you want to know the difference, and you want to be able to handle them because they do like to test that topic. And they haven't done it real recently. So it certainly could be there on the exam. Rent and other income county receives under the stadium lease. That, of course, is a revenue bond if it's a valid revenue bond. And revenue from a new tax the county plans to impose on the value of all notes, bonds, and other obligations for the payment of money. Bells and whistles, right? Because who can tax intangibles? The state, not the locality. So they're trying to set up a general obligation bond, but it's not going to fly because the state and only the state has that power. Now, because of the 3-year limit for occupancy of the stadium, the county wishes to avoid strikes that might delay construction. Bells and whistles. Because what are they going to do? They want to require all contractors involved in the stadium to agree not to employ any labor union members. Bells and whistles again because we are a right-to-work state. They can't do that. So you've got equal protection now as well. The new stadium, and here comes the part where it depends on how much time you have left. The new stadium would be located next to a residential neighborhood. Homeowners in the neighborhood have voiced opposition to the county's plan because they fear that noise and traffic will diminish their property values. Nuisance. Yeah, and maybe taking. Yeah. Both of them could be an issue there. And that's why I say, and it's public nuisance, private nuisance, you got both. But to do all of that and do the bonds and do some of the other stuff that I'm going to talk about, wow, how are you going to do that in an hour? So, and then look at what they add after that. We've got homeowners, and we've got a taxpayer group, and a local construction workers union. What are they setting up there? Standing. 3 different kinds of standing. Now, I do want to tell you, particularly in a Florida con law question, but not just in a Florida con law question, look out for threshold questions. Look for standing, mootness, ripeness, political question, I kind of doubt. But look for that stuff, and jurisdictional issues. Not in this question, but a lot of times they throw in a little bit of jurisdiction as well. Not a big issue, oftentimes, but something that will give you points. So now you're the county attorney, and you've got to advise about everything in the world. And there's a lot here. Sir?
The call to question asks for powers, rights, obligations, and liabilities. Would I also talk about sovereign immunity? And liabilities, that's a liability, and how they can be sued or not? Or
It's a good question, and I don't have sovereign immunity in my answer. But is it outside the realm of possibility they wanted you to talk about it? Not necessarily, because of course if you have nuisance, then you could have a governmental immunity issue. And they'd like to test governmental immunity. You're going to see it usually in a tort question with the, like the Rick Ryder and the bus driver one that you all, many of you did recently. But I can't say that governmental immunity is outside the scope here. That's the problem with a question like this. There's so much. And so you're gonna make some choices. Now, I want to kind of fast forward the first part because I want to focus in on bonds. But look at all the threshold questions that you've got. And I want to point one thing out here, which is this case or controversy advisory opinion, because remember, nothing's happened yet. And so, and the Florida courts can't, as is true for federal courts as well, even though we don't have an express case or controversy requirement, still you got to have a case or a controversy. So it really, it's case or controversy. It's also ripeness. And so you've got those basic issues, which again I'm not going to go through because they're the same as they are under the federal Constitution. I would take, if you're writing this answer, I'd take a few moments to mention that you might have an issue with case or controversy or ripeness. There's a lot more detail here, because people use these as a study guide. Standing, however, I would definitely take time on standing because you want to use the facts. So, and notice in Florida, first of all, that Florida says it has a relaxed standard for standing, but you're still going to use the federal test, right? So you want to look for injury in fact, causation, and redressability, which is what I have here. The three things that you need under the federal Constitution for the individual homeowners. However, we have taxpayers, and we have a different taxpayer standing rule in Florida. It's not fair, is it? They're asking way too much in this question. But just note that we do, because, look, we don't have the limitation that you have under the federal Constitution in terms of taxpayer standing. Because you can have standing in Florida if you have that special injury, or if the taxing and spending power exceeds the limits in the U.S. or the federal Constitution. So we include the federal standard, but we go beyond it because we grant taxpayer standing if they have a special injury. For organizations, you're going to use the same tests that you would use under federal law. And once again, the key here is to understand that they do like to throw in little bits of threshold questions to see if you're paying attention. If you pick them out and you can say something quickly, intelligently about them, you're going to get points that other people are not. So always be on the lookout for them. Now, let's spend some time on the bonds, because that's, I think, the most important issue. And if you're running out of time, you want to make sure that you devote enough time to bonds. They do like to test bonds, and I'm going to give you a format here, how you can approach a bonds question so it's not as difficult to maneuver. What you're going to do first is, obviously in this case, we've got two revenue sources, so we've got to discuss them separately. Don't try to discuss them both together here, because one is set up to be a revenue bond and one is set up to be a general obligation bond. So I went logically with the first revenue source, which was supposed to be a revenue bond. I start out by saying it's a revenue bond because I look at what's being used to pay it back. Excuse me. Sorry. A bond of any kind is just an IOU, right? The government's borrowing money from us if we buy bonds from the government. So the government's got to pay it back. And where are they going to get the money that's used to pay it back? That's what tells us whether we have a revenue bond or a general obligation bond. So first thing you want to do in discussing a bond is identify the repayment source, because that'll tell you, again, what type of bond you have. In this case, the repayment source, of course, is supposed to be the rent and certain profits from the stadium. Now, once we've identified that it's a revenue bond, or whatever kind of bond, but in this case a revenue bond, then we want to know, does the governmental body that's issuing the bond, does it have the power to do so? And interestingly, there's no express provision in the Florida Constitution for counties to issue revenue bonds. But nevertheless, they can. So, you know, and honestly, if you just want to say the county has the power, I wouldn't worry too much about it. You want to be really fancy, you can say the Constitution doesn't expressly give the county the power, but it does have that power. However, important, if the county's going to issue a revenue bond, next step, it's got to be for a capital project. And which is easy in this case, because it's a stadium. Yes, ma'am.
Sorry, can you go back to slide 12?
Yes.
What do they mean by pledging of the full faith and credit of Treasury of Government?
Yeah, pledging of the full faith and credit means that you're just using general coffers to repay the bond. So just that, all that general tax money that's out there. And please, as we're going through, if you have questions, you know, by all means. Yes, sir.
This, I guess, this goes also with you're talking about the mandatory referendum when you're pledging like real property of the state. Would that happen procedurally the same phase? Is that what you want to put that in? If they're validating the bond, do they also want to have a referendum?
Oh, yeah, probably, yeah. Okay, so again, you need the capital project, and then second, it has to be for a public purpose. Now, they gave you a bunch of facts here to help you determine what's a public purpose. So make sure that you use the facts. Anytime they give you facts, try to use them. And I see a lot in a lot of essays, I see people who are able to spit out the rules, but then they just kind of jump to a conclusion. You got to apply the rule to the facts. In this case, public purpose, the stuff that they're telling you. You might not agree, but clearly they're giving you facts that are supposed to at least suggest the conversation.
Would you have a counter argument here about paramount public purpose, since it's the kind of pledging credit on behalf of Sluggers Inc. or Baseball Inc.?
Oh, we're going to get there in a second. Yeah. Okay. Absolutely. Because that's the next slide. Incidental private benefit. And notice I say incidental private benefit because that's what the rule says. If there is a public purpose with an incidental private benefit, then you still have a public purpose. And your decision is the benefit to the sluggers. Is it incidental or is it major? That's your choice. And to make the question work, I decided, yeah, it's incidental enough. It wouldn't matter which you said. I will tell you, though, that I read a lot of cases dealing with this particular subject. And in every single case, they always give the same arguments, the same ones we've seen over and over again here in Miami-Dade County. Oh, yeah, it's going to bring in lots of money, lots of jobs, all this good stuff. And so there's a public purpose, which oftentimes doesn't really materialize. But public purpose with incidental private benefit, when it comes to a stadium, that's what they always say, the courts. Once again, though, if you decide otherwise, it's how you get there, not what you say, yes or no, that matters. So once again, we're kind of marching through because we say first, what's our repayment source so that we can identify what kind of bond we have. Then, does the governmental body have the power to issue the bond? If it does, what are the limitations on the issue? Capital project, public purpose, and of course, incidental private benefit is okay. Question?
Can you just say that again?
Yeah. So you're going to start by saying what kind of bond it is by identifying the repayment source. Then, once you've decided what kind of bond it is, then you have to determine whether the governmental body has the power to issue the bond. If it does, what are the limitations? Capital project and public purpose, with an incidental private benefit being okay. Now, if you have governmental power and they're issuing the bond for the right reason, if you will, then you want to look at the mechanism that's used for issuing or creating the bond. Generally, again, you don't need the referendum, of course, for a revenue bond. But as I said, there's the rule right up there that you were asking about. Again, a referendum is required if the county plans to secure the revenue bonds by a mortgage on the project that's subject to foreclosure. And it's a rule that's been tested several times. Yes, sir.
Does that also apply to state funds?
Yeah. Yes. Now, I threw in a little bit about bond validation. I'm not sure that on the if I were writing this on the exam that I really would, because all that bond validation does is just validate that the proper process was being used. It doesn't evaluate whether the bond is a good bond. Again, if you got a lot of time to spare, you might talk about it a little bit, but it's not essential to the resolution of this particular case. Any questions about the first bond? Okay, second bond, we repeat the process. We ask, what's the nature of the bond? And this time, it's being repaid from that tax, ad valorem tax on bonds and notes and other intangibles. So it sounds like it's a general obligation bond. However, the next question is, does the governmental body, the county in this case, have the power to issue that particular type of bond? And the answer is no, for the reason we just gave, because the power to tax intangibles is vested solely in the state. The state isn't taxing intangibles right now. It has in the past. But counties, localities cannot tax intangibles. And on the exam, I would probably stop right there in terms of this particular bond, because there's so much else to write. But if you've got a lot of time and you want to go through the rest of the process, of course, you can. And here's where I threw in because it did say non-charter county. It really doesn't, because the tax is not going to be valid whether it's charter or non-charter. It really doesn't matter here. Throw in a sentence or two to show that you know the difference between charter and non-charter, and you're done with it. Once again, I wouldn't spend a lot of time on the rest of this. It's there for you to study. The only thing, of course, that you want to remember is that if you have a valid general obligation bond, then, of course, you have to have that referendum. So if you follow those steps, identify what kind of bond it is from how it's being repaid, then look at the authority of the body to issue that kind of bond and any limitations, capital project, public purpose, and then, depending on what kind of bond it is, the mechanism for creating it. Follow those steps, and you've got I don't want to say an easy essay on bonds, but an easier essay on bonds. Questions? Okay. Equal protection. I'm not going to spend a lot of time on equal protection, but we have the right to work. Remember, Judge Shepard told you anything that is in the Florida Declaration of Rights is a fundamental right in Florida. If it is a fundamental right, what level of scrutiny? Strict scrutiny. So make sure that you identify the class, which in this case is union workers. So first thing, if you're talking equal protection, you always have to identify the class. Identify the class, union workers, and then determine whether it is a suspect class, or in another case, whether you have a fundamental right, and quite frankly, the right to work is a fundamental right. So suspect class, fundamental right, and if that's the case, then you go to the highest level of scrutiny. And of course, on the highest level of scrutiny, who has the burden? The government has the burden, and what do they have to prove? They have to prove that compelling state interest and no lesser restrictive alternative. Make sure that, and I see a lot of times when people are discussing equal protection, that it's really fuzzy. It doesn't have to be fuzzy at all. In theory, it doesn't have to be fuzzy. The way the Supreme Court does it, oftentimes it is fuzzy. But identify, again, class, right. Is it a suspect class? Is it a fundamental right? Highest level of scrutiny. If not, likely you're in the lowest level of scrutiny, because there's very little that's in the middle level these days. Any questions on the equal protection? I think I concluded here that it was a violation, because quite frankly, if it's the government that has the burden, it's going to be a tough burden to meet. Now, taking. The taking issue has to do with the homeowners complaining about the noise. And the question is there a taking? They're trying to evoke, and it's common, of course, it's a common complaint by homeowners around a facility. They're trying to evoke Cosbyan overflight cases, right, with the noise. Because remember, with Cosby, the court said there was a taking with direct overflights. Not so necessarily, or at least not a taking per se, if it's not a direct overflight, but that's the type of issue that they're raising here. So let me suggest to you, those of you who have me for property, it ought to look a little familiar. For those who didn't, what do you do if you get a takings question? Once again, a nice, neat little format that allows you to lay out all the information in a really organized fashion. And the more organized your answer is, the more points you're going to get. So 4 steps: private property, then taking, public purpose, public use, public purpose, and in Florida, full compensation, not just. So again, private property, taking, public purpose, and full compensation. Your answers, or your analysis, is going to cover those 4 steps. And you have to have that compensable taking. Property value is considered to be a compensable interest. And that's what the homeowners are complaining about here. The problem is nothing's been taken yet. It's all very speculative. But at least identify the fact that their property value could be the subject of a taking. The taking. Of course, there's no exercise of the eminent domain power here, as we said before, because the government already owns the land that the stadium's going on, and they're not buying up surrounding land. But can we have what amounts to a regulatory taking? Of course you can. It's not exactly a regulation here. But it's, again, it's like those overflights in the Cosby case. So that's what they're trying to invoke. If you have a permanent physical occupation, of course, you have a per se taking. Well, you don't have that here. But a physical invasion may put you in the area of balancing so that you may have a taking. The question is there an invasion here? It's up to you. There's some noise, there's some people, that get drunk and stumble over your lawn, things like that. It's up to you to decide whether it's an invasion. Remembering that nothing's happened yet, though, which is, by the way, the problem with all these cases. There are so many cases in Florida involving construction of sporting facilities. And every single one ends up leaving the facility where it is. Why? Because if you complain before the facility gets built, you haven't suffered any harm yet. And if you complain after it's built, so sad, too bad, right? That's the way all the cases actually go. So again, we're looking at a physical invasion. And it's up to you. You can decide whether it is. I will tell you, though, with noise, there are actually some cases in Florida involving noise from highways. Sometimes you can have, at least in airplane cases, some courts in Florida have found an invasion with noise, but it's an iffy proposition. Particularly difficult in this one because there isn't any noise yet. So if we have a regulatory taking, again, you're going to balance the governmental interest against the invasion of the private interest. You can balance it any way you like, just as long as you do some balancing. Public purpose. Same issue we talked about before, so I don't need to go through it again. They gave you all sorts of facts to suggest that you've got this great impact on taxes and you're going to have more jobs and all that stuff. If you decide, though, that the private benefit to sluggers outweighs the public interest, that's your choice. Just make sure that you reference it. Now, one last thing, full compensation in Florida. The good news is that full compensation in Florida means the same thing as just compensation under the federal Constitution. But make sure you say full rather than just. Yes, sir?
In the case of the nuisance, because of the noise?
We're not there yet. Okay. We'll get to nuisance in a moment, okay? Don't mix and match. Really important. Take each issue separately. So we want to finish the taking analysis first, and then we look at nuisance, right? Okay, any other questions, though, on taking? Follow these 4 steps, and once again, you've got a nice way of organizing your discussion. And the more organized you are, the easier it's going to be on the grader. Have pity on your grader. Your grader is going to have 300 essays to grade in a very short period of time. I'm complaining about 182. 300's almost double what I'm reading. And they've got to grade them quickly. And so don't make it hard. Make it easy. All right, nuisance. Public nuisance, private nuisance. And there are certain categories that are listed in the Florida statute which you don't have to go into, but in particular, a place of amusement is not a nuisance per se in Florida. That's the good news. But can it be a public nuisance? Yes. Remember with public nuisance that you've got to injure something or some right or some interest of the public. So the question here is the noise that this stadium's going to create, is that enough to injure the public's right? Yeah, maybe. I mean, that's your call. If it does, and remembering again, of course, there's no noise yet, then we have to look at the remedy. If you've got a governmental body, then notice that the Attorney General, State Attorney, City Attorney, County Attorney, they can seek the remedy. What about a homeowner? Can a homeowner? Yes. You've got to be someone who can show that your remedy at law is inadequate, and you've got that special injury, which is a rule that you learn in general with the MBE rules for public nuisance. You've got to have that injury that goes above and beyond the one suffered by the public, and your remedy at law, money damages, is inadequate. I wouldn't care if you say yes, if you say no. That's not the issue. It's making sure you walk through the steps that shows you know what a public nuisance is about. Now, private nuisance. You go through the steps. You need the unreasonable and substantial interference. Yeah, I don't care if you say it is unreasonable and substantial or it isn't. Just make sure you mention it. And then you've got to have the interference with another person's use and enjoyment. That's key to nuisance, private nuisance. It's all about use and enjoyment. And you run into the same issues here as you've run into previously. Owners are claiming that their use and enjoyment will be interfered with, but it hasn't happened yet. And so they're going to have a hard time with a nuisance claim. Now, going back to the question that was asked before, at this point, if you're talking about a private nuisance action, and if, and one of the reasons why, I guess why I didn't include it here, because the remedy that's being sought is injunctive relief, not money damages. But if the homeowners are asking for money damages, then governmental tort immunity could certainly be an issue. But you have to get all the way to that point of money damages for governmental immunity to be an issue. So what would I really write about in this question? Because there's so much, and there could be other stuff that I haven't really thought about, but it's a lot right away. I would take a little bit of time at the beginning to talk about those threshold issues, particularly standing, because they gave you the 3 groups. Always letting those facts be your guide. They told you they want you to talk about standing. So I would make sure I hit standing. I would give lots of attention to bonds. I would make sure that I do a really good analysis of bonds. I think I would, and then the equal protection, for sure, because they gave you the right to work. Taking, I really think they did want taking discussed here by the way they set the facts out. So I would spend some time on taking. What would I cut short? The nuisance part. I'd throw in whatever I could fit in at the end if I had 2 or 3 minutes left on nuisance. But that one I would kind of leave to the end because there's so much else that's constitutional that they want discussed here. Any questions? A lot to think about, I know. But what I want you to take away from this question, besides the fact that you go, you know, that's not fair. They can't ask all that stuff. They do. Think about how you present the topics. Key. Think about how we laid out bonds. Think about how we laid out taking. The more organized you are, the more points you're going to get. All right, now what we're going to do now, we're going to take a little break. When we come back, I'm going to take a few minutes, again, to talk about how you lay out homestead, how you would lay out a homestead answer, because I will tell you homestead is something that they might well test this time. And then we'll take whatever time is left over to talk about the family law question, which you've already done. All right. As I said before, just based on what I've been reading from essays, I thought it might be a good idea to give you a roadmap, if you will, for homestead, because it is a topic that they absolutely love to test. And if you can follow, again, have a game plan before you go in, know how to approach a topic and how to write about it intelligently, it makes life a whole lot easier. So with homestead, whether you're, and there are 4 different areas which we're going to be talking about in terms of homestead. The tax exemption, which I have at the end, is the easiest one. Most people seem to get that. But we have to talk about restrictions on devise of the homestead. That's one. Restrictions on devise of the homestead. We're going to get there in a second. That's one of the areas. The second area is protection of the homestead from creditors during the lifetime of the owner. And the third is protection of the homestead from the owner's creditors after the owner's death. Those 3, I see people kind of mixing up all the time. And then, of course, the 4th, the tax exemption, which is, again, the easiest. So whatever you're talking about, though, whatever of the 4 that you're talking about, first thing you have to do is talk about the basic requirements. That part's usually easy, although occasionally I see people kind of tripping. So what do you need? You need tripping in several different ways. You need a natural person. And the only thing that I would kind of look out for, at some point they're going to do it, is the owner who puts the homestead into a revocable inter vivos trust. There's a little bit of controversy in Florida over whether it's still owned by a natural person. I wouldn't worry too much about it, but just remember, if you see a revocable inter vivos trust that is funded by the homestead, that the third DCA, and Judge Shepard told you when he was here, he absolutely insists, because I've talked to him about this particular issue several times, absolutely, if it's in a revocable inter vivos trust, it's still homestead. Why? Because the owner still has control, because you can revoke a revocable inter vivos trust anytime you like. So the third DCA believes very firmly that it's still protected. Some bankruptcy courts sitting in Florida have said no. Again, kind of an open issue, but for the most part, just look for a person. How much? Inside a municipality, up to 1/2 contiguous acre. Pretty easy. And of course, limited to the residents. Outside the municipality, that's where you get the 160 acres of contiguous land, including improvements. Again, there's a little bit of a split of authority on the improvements, a couple of cases involving mobile home parks. Some courts, and it's probably, I would say, the majority view, if there is such a thing, say that the homestead protection, as long as you're living on part of the property, and if you've got a mobile home park on some of the rest of the property, the whole thing's still protected. But not all courts have agreed. Some have limited the homestead protection to the part where the owner actually lives. Again, just something to think about. Important, of course, has to be the permanent residence of the owner. But remember, the owner or the owner's family. And oftentimes, they'll give you a situation in which the owner lives one place and the family lives someplace else. In that case, you could actually probably have 2 homesteads. And then finally, just to throw in, it never seems to affect the outcome of the case. But don't forget, you get $1,000 personal property protection, homestead protection, which is different from exempt personal property protection under the probate code. It's different from the family allowance. It's just a homestead, extra $1,000 for what's in your house. So first thing up, whatever the homestead issue is, of course, identify the homestead, following again those steps. And with permanent residents, sometimes they'll want you to think a little bit about whether the homestead's been abandoned, right? Because it maybe the person lived there and then moved someplace else. For abandonment, it's just like abandonment of any kind of property. You have to intend to abandon, and you have to do the act. But just going someplace on vacation or for a couple of months, that's not going to amount to abandonment. Yes, ma'am.
When the family does not live there, it doesn't.
When you say the family doesn't live there, nobody lives there, or?
No, the family of the owner doesn't live with the owner.
Oh, if the owner lives one place and the family lives somewhere else, the owner could have homestead in 2 places if the owner owns both of those houses. Because the owner can still have homestead where he or she lives. And then if that person owns the house where the family's living, you could have 2 homesteads. Any other questions on that particular area? All right, so now let's look at testing topic number 1, if you will, which is restrictions on devise. And don't mix it up with the other 2 testing, or the other 3 testing areas, because I'm seeing a lot of stew, if you will. This is all kind of mixed up. So first things first, if the homestead is held in tenancy by the entirety, which it oftentimes is, then just use your rules for tenancy by the entirety, period. The surviving spouse takes by the right of survivorship, end of story. Remembering also in Florida, a couple of things. One part's easy, one part I'm seeing some people get a little mixed up on. If property is placed in the, real property, is placed in the name of 2 persons who are husband and wife in Florida, we presume tenancy by the entirety. You do not have to express the right of survivorship for tenancy by the entirety in Florida. You do for joint tenancy, but not for tenancy by the entirety. But where I'm seeing some mix-up, if property is held in the name of just one spouse, that spouse is the sole owner, it is not tenancy by the entirety. It's not presumed. So make sure that it's titled in the name of both if you're going to talk about tenancy by the entirety. And then even if it's homestead, it just goes by the right of survivorship at the death of the decedent, whoever that is. Now, what about a devise of the homestead? Now you have to ask who survives the owner. If the owner is survived by a spouse or a minor child, then the owner can't devise the homestead. Be a little careful about that, though, because you may have someone who executes a will now, a relatively young person who has a spouse and little kids. And that will could include a devise of the homestead. It's not void right from the beginning. Why not? Because the will has no effect at that point. Time of death, exactly right. So you're going to apply this rule at the time of death. If there is a surviving spouse or a minor child at the time of death, then the devise of the homestead is void. If, on the other hand, you've got a surviving spouse but not a minor child, children, that's fine, but they're not kids anymore. So if you've got a spouse and children who are 19, 20 years old or whatever, then the owner may devise to the surviving spouse, but nobody else. And I should have put there, I thought I did, but I didn't. If there's no surviving spouse and or no minor child, the owner can devise the property to whomever he or she chooses. So kind of write that in. Should have put that there myself.
You said you can devise to whomever he chooses. Is that true?
That's right. Now, the separate issue will be whether it's protected homestead in the hands of the devisee. We'll get there later. But yeah, if there's no surviving spouse and no surviving child, the homestead can be devised to anybody.
If there's a spouse and adult children, it would go be simple to the spouse, right?
We're not there yet. So you don't want to mix and match. Because all we're talking about here is, can you devise? Your question says, what happens if there's no devise? That's the next step. And that's what I'm saying again a lot. I see a lot of confusion, so go step by step.
If there's a spouse and adult children, can they devise the property to someone else?
Who can you devise it to if you have a spouse and adult children? No spouse. If there's adult children but no spouse, you can devise it to anyone you like. If there is a spouse and adult children, you can devise to the spouse.
But if there's only children?
Then you can devise to anybody you like, if it's just children. If they're adult children.
No, but minor children.
Minor children, you can't devise it to anybody. Right? Somebody else had a hand up in the back? Yes, sir.
I mean, I guess like most of us have done a lot of homestead essays at this point, so I guess my question is really like sort of like source of law almost. It's like, are you going to have a survivorship due to tenancy? Are you going to have it because of the devise? Are you going to have it because of actions? And is that how we kind of want to organize the essay?
Well, what you want to do is, because I've read a lot of your essays, so that's why I pulled this out and decided to do it. Because I'm seeing, like I said, this stew. You're just mixing everything up. You got to separate out the issues. And I'm not just separating out the issues. The Florida Supreme Court, in its opinions, identifies these different areas. And you want to identify these same areas because that's what the case law does. So if the issue is devise of the homestead, which you do not want to confuse, by the way, with an inter vivos grant of the homestead. That's a whole other issue, right? So devise of the homestead. Then you follow the steps I just described. And if you want, let me just add that in on Okay, it's not grammatically correct because I'm just trying to get it up there. Okay, so again, no spouse, no minor child. You can devise to anybody you like. Okay, now, step number 2. If there is no devise in the will, or if you have a spouse and a minor child, or just minor child so that the devise is not proper, what do you do next? That's when we go to rules of descent. And we start with the traditional rule, which is the spouse takes a life estate, and we give a remainder per stirpes to the lineal descendants in being at the time of the owner's death. That's the traditional rule. Of course, we have a recent statutory change, which gives the spouse an election. And the spouse can elect. Oh, I'm sorry. Yeah, I'm sorry. Okay. Yes, sir. I can certainly, and I'll even make that one sentence grammatically correct. We can, yeah, we'll send these out to you. Actually, what we'll do, rather than send them out, we'll post it. It'll be a lot easier. We hopefully have a, here's what I'll do. I will send it to you by email if you get it, but we'll also post it. All right, because we do have your emails from today. Are we still working on this one? Okay. So, election by the spouse and what happens. I have a little more detail than I am going to talk about here, but of course the spouse may now elect to take as a tenant in common with the lineal descendants. The spouse gets half, and the descendants get the other half as tenants in common. And honestly, that's what's going to be happening now, because that legal life estate that the spouse used to get is worthless. So that's our, I'm sorry?
So what was worth it?
The legal life estate. Legal life estate just has no value. So if you get a question about whether the homestead may be devised, here are the steps, which I just outlined, that you go through. And don't mix it up with the other issues, which may also be raised by the facts, but take them separately. Because again, that's how the courts do it. That's how the grading outline is going to be written. The closer you get to the grading outline, the more points you're going to get. Any final questions on devise or descent?
So would a BFP always lose on the inquiry notice?
Oh, it has nothing to do with what we're doing here, okay? Because you're talking about recording.
Last interview was one.
And you're talking about recording. Nah, don't even go there. We're going here, okay? That's why I keep saying, don't mix them up. You might like to have a nice stew right about now because you might be hungry, but it doesn't make for a good exam answer. Okay, next. So we don't need that. Okay, next topic. Protection from creditors during the owner's lifetime. So we know that generally speaking, the homestead is protected from the owner's creditors during the owner's lifetime, with 3 exceptions, all of which, if you have in this area and in wills and trusts, when in doubt, you're going to have 3 exceptions. Everything comes in 3s. I don't know why, but it does. So if you're stumbling, say, wait a minute, there's got to be 3. 3 exceptions, all of which grow right out of the property. So it's easy to remember them because they grow out of the property. First is taxes and assessments. Makes perfect sense. If you don't pay your property taxes, the government can come after your homestead. Second, obligations contracted for purchase, improvement, or repair of the property. It's invariably going to be a mortgage. So if you don't pay your mortgage, the lender can come after the homestead. And the third, obligations for house, field, or other labor performed on the realty, which results in a mechanic's lien. If you have somebody come in and fix your roof and you don't pay the person who fixed fixes your roof, that person can come after the homestead. So this is topic number 2. And it's pretty simple, actually. And it's not an area where people get too confused. But any questions on topic number 2? OK, number 3. Here's where I start to see people getting all confused again. Protection from the owner's creditors after the owner's death. And I see people getting mixed up with creditors of the devisee and this and that. No, we're talking about homestead protection of the property once it goes from the owner to somebody else after the owner's death. So homestead protection from the owner's creditors may inure to the following parties in the following situations. If the surviving spouse takes the homestead by demise, of course, again, if you don't have a minor child, the surviving spouse will take free of claims of the owner's creditors, not his or her own creditors until the homestead is reestablished in that person's name, but the owner's creditors. Unless, of course, you have one of those 3 exceptions. Second, homestead descends to the spouse and lineal descendants if the surviving spouse elects to take as a tenant in common with the lineal descendants, or, and this is the one that I tend to see people not really understanding, if there is a valid devise to somebody other than the spouse, which means, of course, you don't have a spouse or a minor child, right? Then, as long as the devise is to somebody who could be, not is, but could be an heir at law under the rules of intestacy, that person takes the homestead free and clear of creditors' claims. And who could be an heir at law? Anybody in those 3 parentellas, right? Any descendant of the grandparents of the decedent, or descendant of the grandparents of the last deceased spouse, if you have a last deceased spouse. Anybody who could, not will, not must, but who could take by intestate distribution. If the property is devised to that person, then it's free and clear of the owner's creditors' claims.
But not of taxes and
Right, correct. Any of those 3 exceptions still apply. Absolutely.
You said as like a final effort, it'll go to the last known spouse's descendants.
Right. Remember, under the intestacy laws in Florida, you go lineal descendants first, then descendants of parents, then descendants of grandparents. If you get down to the bottom of the third parentellum and you still don't have anybody, before the property escheats to the state, what do? You go to the relatives of the last deceased spouse and you do the 3 parentella again. Questions? Yes, sir.
Okay, let's say it goes to a friend.
Okay, if it goes to a friend, it's not going to be protected from the owner's creditors.
The homestead property is not going to be protected, meaning the guy had a debt and credit card, so now they can file a judgment to attach to the property, even though it goes to a friend.
Right. If it's a friend, that friend, assuming the friend is not a descendant of the owner's grandparents, then the homestead protection will not inure to that friend, which means the friend will take subject to the creditor's claims. Now, 4th category, tax exemption. I'm not going to say much because, again, I usually see people spit the rules out, and that's about all you have to do. Your basic exemption up to $50,000, right? And then I'll leave that up for a second. But then there are other exemptions, specific ones for the elderly and also for military persons. So just have, and you don't have to get real specific, but this first one you should know, up to 50,000, which people usually do know, and then a little bit extra for the elderly and for military personnel. But that's exemption from taxes, right? From your property taxes. So what you do, of course, if it's the 50,000, you take the value of the property, the assessed value of the property, and you subtract out the 50,000. And that's all you would have to do on a question that's dealing with the tax exemption. Leaving aside, not even getting into the caps and portability. That's a whole separate issue. So I promise you, if you can separate out these issues instead of mixing them all up together in your presentation, you're going to get a lot more points. And is it worth spending a few moments thinking about this? Yeah, because it's a topic they love to test. Any other questions on the homestead? Okay, now, and I will make sure this gets sent out to you. Probably won't go out till Monday, but we'll get it out Monday morning. The last thing, and let me ask you, how many of you did not, makes it easier, how many of you did not do this question with husband and wife, and the husband has the affair with nurse, and so some people didn't? Okay, wow. Okay, can we do this? Can we give them just, for those of you who have done it, give them just a few moments to read it, and then I'm going to summarize because you've got the slides. You know what? Let's read it together. And so you guys who've read it don't have to sit there and wait. Let's read it together. It's a fair, let me turn this over. Okay, this question, I like to use this question, and obviously Barbary likes it too, because it covers the kinds of issues that they love to test in the area of family law. And the good news is that if you get a family law question testing the subjects in here, there is a way to write the answer. Because the first thing you have to do is address equitable distribution. The statute tells you you have to address equitable distribution first. And then you talk about alimony. And then you talk about what's now called parental responsibility rather than child custody. And then the last thing you talk about is child support. Now, of course, there can be other issues. There could be some adoption in there. You could have some UCCJEA issues. And maybe they throw in some dependency. Exactly how, I'm not sure, but they could. But once again, a typical family law question. So let's do a little bit of issue spotting, which many of you have done. And then, as I said, I want to point out some things that you probably didn't think about when you wrote this question, unless you happen to know the case law, and maybe some of you did. And then I really want to also demonstrate how you want to avoid big blocks of law and kind of break things up. So, husband and wife met in college and married after graduation. Now, when I read this question, I know exactly where they're going. It just, you know, you're going to set up a situation in which husband goes to college, goes on to graduate school of some kind, gets a good degree, has a good living, wife stays home, takes care of the kids in the house, and then he divorces her and trades up, right? That's the fact pattern. Now, stereotyping, you bet. The question was written in 1996. Today, it's equal opportunity, folks, right? Because it can be the wife who does the trading up, okay? Now, I want to caution you all, should you get a family law question, do yourself a huge favor. If you've had a less than pleasant experience in the area of family law personally, do not bring it into your essay. And you laugh, but you would be amazed at the venom that sometimes gets spilled out on the page. Whoa. Not particularly helpful, okay? Try to be as clinical and as dispassionate as you can, if you can. All right, so husband attended medical school while wife worked in the local department store. Why is that back there? Alimony, right? And not just alimony, it's a factor that's also relevant to equitable distribution. But I want to caution you on equitable distribution. The case law is pretty clear. Divide it down the middle for equitable distribution and then make up for inequities in alimony. So even though you're going to say that the court doesn't have to divide it down the middle for equitable distribution, that's true, they always do. So just remember that as you're writing your answer. And those statutory factors, there are statutory factors for equitable distribution. There are statutory factors for alimony. There are statutory factors for parental responsibility. Make sure you say at least that much as you discuss equitable distribution. Say, and yeah, there are a bunch of, well, don't say a bunch of, but there are many statutory factors. I see a lot of people just skipping over that. That's an important part of the process. Do you need to memorize the big list? Some of you might already know the factors. If you do, great. If you don't, I wouldn't necessarily memorize the whole list, but be able to spot them in the facts like we just did. Because when you spot it in the fact, then that'll trigger the factor in your head, and you can talk about it. So, wife had been expected to law school, poor soul, right? But she decided to get a job instead to support husband. Once again, could be relevant factor for equitable distribution. It could be for alimony as well. Husband paid medical school tuition by withdrawing money from a trust fund his parents gave him before his marriage as a graduation gift. So we know the trust fund itself is non-marital property. And paying tuition, who cares, right? And we also know, of course, that his medical degree is non-marital property. The only place that a degree is marital property is in New York. So the medical degree itself, non-marital property. Husband's trust fund contained $500,000. You're not going to have to do any math, so I'm not real sure why they even gave you the dollar sum. Husband and wife bought a $200,000 house in Tampa, Florida, with money from the trust fund. Now, it's very vague. They just say they bought a house. It doesn't tell you how the house was titled. For the purposes of my answer, I said I'm going to assume that they titled it in the name of husband and wife, which means it's presumptively tenancy by the entirety. But you at least have to maneuver through the vagueness in the question. The fact that money from husband's trust fund was used to purchase the house. The time this question was written, there was a case that was working its way up through the district courts of appeal, several cases. No, just one case, I'm sorry. Up through the district court of appeal to the Florida Supreme Court. And they used that particular case as a basis for part of this question. The more you know about case law, the more you know. And there is a particular rule, which I'll talk about in a moment, that is evoked by that particular fact. That's the part of the question that most of you kind of went, oh, right? You're going now, oh, what was that? It's there. If you knew the case law, you'd see it. I'll explain it in a moment. Question? Yeah, I will answer it. Mortgage payments and taxes were paid by the trust fund. That part of the trust fund that's actually been used for those payments, of course, is technically marital property, but it's gone. So it's really not an issue. Wife paid all other living expenses while husband attended medical school. Her contribution to the marriage, right? And the contribution of each spouse to the marriage is relevant to not only equitable distribution, but also alimony. Now, of course, 4 years later, husband graduates, begins a residency, and wife quits her job, stays home, and raises the 2 children. Her service as a homemaker, once again, is relevant to equitable distribution. It's relevant to alimony. Husband, of course, becomes a successful doctor, which is going to suggest that they have a certain level of living, right? Which is relevant to alimony, right? See how you want to use those facts. Husband worked long hours and did not spend much time at home. Relevant for what purpose? Child sharing, right, yeah, whatever you want to call it. Believe me, I always say child custody, and I have to stop and say, wait, no, not the right word. But anyway, yes. For their 15th wedding anniversary, which means, of course, they haven't been married how long? 17 years. At the time this question was written, that 17-year rule wasn't in place, but the question still works, right? Because it's not a long-term marriage. It's a middle-term marriage. Husband bought wife a $40,000 sports car. I see a lot of people making an error with the sports car. It is a interspousal gift, which is marital property. Gifts acquired during marriage from somebody else, they're not marital property, but an interspousal gift is marital property. Wife appreciated the car but really wanted husband to spend more time at home. Anybody know why that fact was there?
For purposes of parental responsibility?
Well, it might be, but in the car, she says, thanks a lot, but I don't really want the car. It's relevant to what? Yes. Is the car going to go to her as a partial lump sum, if you will? She could take the car as part of her equitable distribution, but she doesn't want it. So what are they going to do? They're going to sell the car and divide up the asset. Yeah. So that, again, really let those facts talk to you. Unfortunately, husband's absence from home is due in part to an adulterous affair he was having with nurse. Important, because I've seen some errors on this particular point. For equitable distribution, there is no factor that addresses adultery. There is for alimony, but there isn't for equitable distribution. Now, traditional rule, of course, when it comes to adulterous affairs is it's not relevant unless it does what? Depletes the assets, right? So that rule is still in place. But remember again, there is an express factor for alimony that takes into account adulterous affairs with that qualification again, that it depletes marital assets, case law qualification, but no parallel factor for equitable distribution. So shortly after the 15th wedding, we already talked about wedding anniversary, we talked about the length of the marriage. Wife discovers the affair, she files for divorce. At the time of filing, husband and wife are 37 years old. Relevant, certainly, to alimony. They're both in good health, it appears. Daughter is age 11 and their son is age 8. I think the ages were there for a reason. Because what do we know about children in terms of parental responsibility? They can say who they want to live with if they're old enough. Now, what I think, and here's where we may get some disagreement, depending upon who you are out there. An 11-year-old girl, I hate to say it, guys, but girls mature faster and earlier than boys do. Sorry, but it's true. 11-year-old girl probably could give her preference. 8-year-old boy, not so sure. So, but you can say whatever you like. I think, but just make sure you discuss it. So, now, look at the call of the question. Discuss the following issues that may arise, and they give you the issues in the right order, which is not another reason I like this question. Distribution of property, equitable distribution, alimony, child custody, which today you call parental responsibility, and child support. Now, sometimes, occasionally, they do, where'd that go away? Okay, hang on. They do take the issues out of order. If the call of the question goes in another order, follow the call of the question. Otherwise, follow that order. Equitable distribution, alimony, parental responsibility, and child support. I throw a little bit into this question. It's not relevant, but always be thinking about, is there a pre or a post-nup agreement? Always kind of keep that in the back of your mind. Question?
I was going to actually ask you or comment on what you said. Because sometimes, I guess we've all been training our brains. Want to put something in a certain logic order, we should always follow when they're asking for the question.
Oh, yeah. the reason, the logical order, the correct order here is the one I just gave, and the one that is in the call of the question here. But I have seen questions, because I sit there and I read all those questions. I've seen questions where they've taken it out of order in the call of the question. Follow the order of the call of the question, because that's the order that the grading outline is going to be in. And the closer you get to the grading outline in your answer, the more points you're going to get. So really do try to follow the call of the question. Hopefully they're not going to take you out of your comfort zone, if you will. All right, now let me go forward and show you a couple of things that I would recommend that you try to do. I'm not going to go through the whole thing, although, stop me if you have questions. For equitable distribution, of course, first of all, you want to identify Florida as an equitable distribution state. Kind of goes without saying, but we are. And if you want to give a quick list at the beginning of what constitutes a marital asset, you can do that. But don't write a page full of rules about marital assets. It's too hard to slog through, and the grader's going to get lost. So notice what I've done here. I listed them all. Those aren't relevant to this question, and quite frankly, if you're pressed for time or you can't quite remember, you don't have to list all the different types of marital property. Go for the ones that are relevant in this case. So go right to interspousal gift. But state the rule for interspousal gift during the marriage between the spouses, and apply it immediately to the facts. Weave law and fact together, because that's what good analysis is. And it also makes it a whole lot easier on the grader.
Can you just step back for 1 second, back to the agreement for homestead?
Yes.
You can waive homestead.
Yeah, absolutely.
Agreement, but it has to be in a certain
Yeah, let me explain that. With homestead, it's what's called a statutory family protection. And a spouse may waive all of those statutory protections. Homestead, elective share, predetermined spouse, family allowance, exempt property, all that stuff. That can be waived. But it has to be in a writing. And if it is a waiver before the marriage, no disclosure is required. This is for statutory rights only. There are different rules for property. If it is in a postnuptial agreement, then full disclosure is required. That's, again, for your statutory spousal protections.
Do you need two subscribing witnesses?
Yes. You do need the two witnesses. You don't need full will formalities unless it's in a, well, if it's a pre or post-nup agreement, it's not going to be in a document with testamentary aspects. But yeah, you need the witnesses. Okay, so once again, try to break it down. You've got to make it visually easier on the grader, too. A big block of rules is very hard to read. Go by category. So we're going to analyze the interspousal gift. So notice what I do. I sort of spotted the issue, and then here's your rule. Apply it to the facts, conclude. Your little mini IRACs. It's much easier to follow. What do I do next? I go to property that's held in tenancy by the entirety, which is presumed to be marital property. And here's the case that I talked about. Because husband used his own separate funds to buy the property. But according to this case, Robertson versus Robertson, if one spouse uses his or her own separate funds to buy property and places the property in the name of the two spouses, that spouse who paid for the property is deemed to be making, or presumed to be making, a gift to the other spouse. And so the entire property will be marital property. So remember again, if one spouse buys the property, places it in the name of both spouses, which then will be presumed to be tenancy by the entirety, the spouse making the purchase will be presumed to be making a gift to the other spouse, and the entire property becomes marital property. Now, non-marital, of course, the main thing here, of course, is the trust. Husband got it before the marriage. He maintained it separately. The trust itself is separate property. In this particular case, there's nothing to indicate that the wife helped increase the value of the trust, right? You've all done, a number of you have done a question involving an appreciation in value of non-marital property. If the spouses together create the appreciation in non-marital property, then the appreciation becomes marital property, but not the asset itself. Now, factors. There are tons of factors. Once again, you don't necessarily have to memorize them all or be able to spit them all out, but be able to spot them in the facts. And state a factor, apply it directly to the relevant facts. And you can see what I did here. Contribution to the marriage of each spouse, and I say, in this case. Economic circumstances of the parties, in this case. Why do I do that? Because if you list all the factors first, you're going to fill up a whole page, and then you're going to go to the next page, and you're going to list a bunch of facts. And what's your grader going to have to do? Back and forth like this? Don't. Put them together so that the grader can see that you see how the law relates to the facts, which gives you the analysis. Now, what you're going to do then is you're going to repeat the process, of course. And let me go forward to one factor in particular. Here we go. OK. I'm not going to go through all the factors now. You can look at the packet. But finally, we get to desirability and feasibility of retaining the marital home as a residence for dependent children, clearly raised by the facts here. And so you want to address that factor, and the court can order the home to be maintained. It's marital property. And if you didn't have kids, you'd just sell the property and split it unless, and I've seen this in questions, one spouse says, I really, really want the home. Well, that can be a lump sum if you like. But in this case, they're probably not going to give the house outright to the wife, but instead they'll preserve the home as a marital asset until the kids reach the age of 18. So the spouse with primary residential responsibility, which in this case is probably the wife, will live in the house with the kids. When the kids reach 18, they sell the house, they split the assets. Questions about equitable distribution? Those are the main issues in this question that you want to address in terms of equitable distribution. Yes?
In a case where the property is in one spouse's name, but they both live there, and appreciation over years, how does that play into this?
If the house is in the name of one spouse and it's separate property, and which they've tested, certainly from time to time, the spouses live there, and if they both contribute to the appreciation in value, the appreciation in value itself is marital property. The house is not. The base value of the house is not, but the appreciation in value is.
If the one spouse contributions, they were being a house rent, does that count?
It could be. If she's the one who makes sure it's painted and the garden is kept up and stuff like that, sure. Other questions on equitable distribution? OK, alimony. Remember also with alimony, because I'm seeing a lot of stew when it comes to alimony too. You can, as I've done here, you can list out the various kinds of alimony. And I actually put more detail, again, because people use these as study guides. You can say, Florida has the following kinds of alimony. No problem with that. But then analyze each one separately. Again, Don't give them 2 pages of rules about alimony and then try to make a resolution. So in this particular case, let me get forward to where I did it. I'll come back to some of that. It's a lot of steps. Here we go. Okay, so bridge the gap. Yeah, probably bridge the gap because she's a homemaker and she can't generate income right now. Remember, bridge the gap, it's only 2 years. Rehabilitative alimony. Yeah, she wants, poor thing, she wants to go to law school, right? Yeah, you tell her don't. Remember also, and I have it in an earlier part, with rehabilitative alimony, you have to have that rehabilitation plan, right? So make sure that you mention the rehabilitation plan. What about durational or permanent? I did put those 2 together because it's going to be one or the other, not both. And in this case, because the marriage is 15 years, it's not automatically eligible for permanent. I'm guessing they would go for durational here, which cannot exceed the length of the marriage, but 15 years is a fairly long time. Once again, though, try to break them out and analyze each one separately if you can. Little mini IRACs, much easier to follow. Much, much easier to follow. Questions about alimony? And you know what? You can give any award you want here. If you think she doesn't deserve anything, okay. Some of you might be thinking that. If you think she deserves everything, that's okay too. But just make sure that you make your analysis in as easy a fashion as possible to follow. Yes, sir?
With modification of alimony, cohabitation, is it actual cohabitation or is it more just if you can show joint accounts and
That's, it's, yeah, sure.
Excuse me, are you saying we should say how much money?
No. No. You don't need to get into dollars. But just say whether it's going to be durational or permanent and or rehabilitative. Specify the types of alimony, not the dollar amount. Okay. Parenting or parenting, responsibility. You get 1 free bite at the best interests of the child. And do say it once. But do not begin every sentence with the best interest of the child. It gets old fast, right? So mention it and then move on. And interestingly, in Florida, it's not just the best interest of the child. If you want to sound like you really know what you're talking about, it's in the best interest of the child and in conformity with the UCCJEA. The statute actually says in conformity with UCCJEA. Throw it in. That's a place where you get an extra point, right?
There are like 20-something statutory factors for best interest of the child. Is there like a good bloodline,
Yeah. What you should, it's a good question. And when you get there, and if you go back here, statutory factors. I put it kind of at the end, so because I'm going to go first through the general rule and then that parenting plan, which is really important today, and then I'll say, and we have all these factors. What I would do is say there are multiple factors, including but not limited to the following, and then I would break out the ones that are supported by the facts. You can list, if you know them all, you can list them all, but that's a lot of learning to do. If you don't already know it, don't clutter your brain. But be able to spot them in the facts. That's the good thing about all those factors. They are going to give you facts, like the age of the child. As soon as you see it, you say, oh yeah, that's a factor for parenting responsibility. And they tell you that husband's away a lot. That's another factor, right? Because the closeness of the parents to the children, that's a factor to be considered. Okay, now, I've noticed that some people have kind of skipped over the parenting plan. You don't have to go into a lot of detail with parenting plan, but make sure that you mention it, because the parents have to put the plan together. If they can't, the court's going to make one for them. but the initial responsibility is with the parents, and perhaps some of you have had some experience with it. It's detailed. Parents have to divide up all of the different functions that are involved in being a parent. Who's going to take the kids to school? Where are they going to live? Who takes them to the doctor? Who takes them to soccer practice? Whatever. Make sure that you give good attention to the parenting plan, which again has to be approved by the court. Now, factors again. When you get to the factors, try to weave the facts in with the factors, and you can certainly just go to the factors that are raised by the facts. You don't have to list them all. Also, remembering, and certainly what they're aiming for today, first of all, joint parental responsibility. In almost every question, they're looking for joint responsibility. There's one question from a ways back in which I think it was the mother took the kids and went to live in a cult that handled snakes, venomous snakes. Okay, maybe you don't want to give her joint parental responsibility, but it's going to be an extreme situation like that, right, where there's danger or some other kind of problem with the children. Otherwise, they're going to share, right? And however, you could say here that she's going to be the primary residential parent, right? Because they give you the fact that the kids have lived in the same house their entire life and they've gone to the same school. So those are the kinds of factors. So the parents divide it up. Wife gets primary parenting, husband gets something else. Any questions on parental responsibility? All right, bringing up the rear, child support. The good news on child support is that you can't take a calculator into the exam, so they cannot get really specific. And for those of you who have some experience in the area, there is a set of statutory guidelines. It's a huge table. It goes on for pages and pages and pages and pages. They cannot possibly expect you to memorize all that stuff. So all you have to do is kind of mention that it exists. I rarely see people not recognize that both parents have a duty to support. So you certainly start with that premise. And then I would mention the worksheet. I wouldn't go into detail. Once again, it's kind of like the parenting plan. It's the steps the parents have to go through to get to the point of child support being given. And really, on the statutory guidelines, if you can remember, if you're below $800 per month combined monthly income, then it's just on a case-by-case basis. Most cases fall in this gap or in this area between $800 to $10,000 a month. And then that's when the statutory guidelines just fall right in. When you have a really high income, then it depends on how many kids there are. Now, make sure, and I've seen a lot of people leave this particular point out, if you're talking about child support, make sure you mention the court's power to vary from the statutory guidelines plus or minus 5%, right? Don't forget about it. There is, and here again, if you mention it and you can't remember all the different categories, kind of look at the facts and they'll help you remember. Because, for example, here, you don't really have special needs, but if they give you a special needs child, then the court's got to be able to step in and vary from the guidelines. There's also that mandatory variance, which I kind of doubt that they'll test, but there it is. Okay, any questions on child support? All right, now let me tell you what I'm going to do next week, a little bit about what I'm going to do, especially for those of you who are trying to decide, you know, how do I best use my time? Because you have an exam coming up, right? Small little detail. What we're going to do next Wednesday, and it'll start at 1. It's set for 1 to 5, but sometimes those sessions go on for a long, long time. I've been here 6, 7 hours sometimes with students, and I'll stay here as long as students want to stay here. What I do is I cannot go through every subject in detail. Plus, you really don't want me to at this point. What I do is I kind of give you an overview, a game plan for subjects. I got a request about First Amendment. How do you approach a First Amendment question? It's that kind of thing that I do. You know, game plans and broad views of subjects. If you have a specific question about a subject that I'm able to answer, I will certainly do that as well. But I do not intend to go into any subject in a lot of detail, because that's not going to be real helpful. So it's overviews, game plans, how do I think about topics. And if there is anything besides the First Amendment that you particularly want addressed, again, assuming it's something I can address, First Amendment I certainly can, I will be real happy to do it. You can shoot me an email. For those of you who are coming next week, we'll see you next week. If you're not, and if I will not be offended if you don't come next week. I just want to say a couple of things. You guys have been terrific this summer. You've really shown up, as the dean said, in record numbers, which is a really good sign. So we see the students who are engaged, the students who come to these classes, the students who write essays for me are the people who pass the bar exam. And those essays, I am sorry that I had to institute a cutoff. But I kind of did, because I have to get them done in enough time for you to get some decent feedback. But I have to tell you, last year was the record, and I had 96 essays. This year I have, I don't know, it's 182, 183 essays. So again, my hat's off to you guys. You've really been working hard, and I think your efforts should translate into great scores on the exam. So for those of you I don't see next week, I wish you the greatest of luck. For those of you I will see next week, I wish you luck too, but I'll do it again next week.